I don't know if the Lord Chancellor is trying to break the world record for the number of manifesto pledges voted in one bill, but if he is, he's made a good fist of it.
Elfyn Llwyd.
Thank you, Mr Deputy Speaker. I'm going to speak against much of this bill, but probably not as voraciously and as vehemently as the previous speaker. This bill does, in fact, serve two different purposes. It attempts to advance and also set back our legal system. And I'm reminded of a section in Lewis Carroll's Alice Through the Looking Glass, in which the heroine takes one step forward only to find herself taking 2 paces back. Some of the reforms to sentencing which are proposed in Part 3 of this bill, I believe, will tidy up current sentencing framework by correcting some anomalies surrounding release on licence. Yet, the concurrent cuts on legal aid that we're being asked to push forward, these cuts will hijack any claim our legal system has to being just. And in my contribution today, I will briefly set out my reaction to both aspects. Although I mentioned Lewis Carroll, I hope it won't seem too topsy-turvy for me to start by considering the end of this bill first. As I mentioned, Part 3 of this bill introduces some positive reforms. My particular interest, however, lies in clauses 93 to 96. And in February of this year, I introduced a 10-minute rule bill with the aim of correcting various anomalies in sentencing, and I'm exceedingly pleased that some of these proposals have been included in this bill. The aim of my bill was to ensure that prisoners serving determinate sentences of 4 years or more, as well as those serving indeterminate sentences for public protection, are only released back into the community when a parole board has determined they are at low risk to the public. And I was helped in this by Harry Fletcher of NAPO, who assisted me in the arguments. Incidentally, my bill also argued that sentencers should have the ability to have regard to mental health problems when sentencing convicted persons. Clause 62 of this bill goes somewhat towards realising this, and I'm pleased to see it. Under Section 244 of the Criminal Justice Act 2003, when a fixed-term prisoner served the requisite custodial period, the Secretary of State shall release him or her on licence. Since 2005, however, those serving 4 years or more have come out after serving over only 50% of their sentence, regardless of any progress they made in prison. My bill proposed to add a sub-clause to this section that would ensure that before release, a person sentenced to 4 years or more in prison, the parole board must be satisfied that the individual is at low risk of harm to the public and low risk of reoffending. Clause 94 does go one step forward in this regard, in that those released are not automatically eligible for home detention curfew. And I think that's a step forward in any event. My bill also suggested a reform of the controversial indeterminate public protection sentence, and I understand from what the Lord Chancellor said today there is to be a review of that, and I'm sure that's welcome. But of course, the devil will be in the detail, but it's long overdue. Something has to be done. And as the Honourable Lady said earlier on, one of the main problems is there are no courses for these people, and that's the backlog. That's where the wall is currently. But I'm glad that this thing will be looked at because it's well overdue. I would still press the fact that participation in the offender management programmes should be taken into account when deciding whether to release a prisoner on early release. All things considered, I'm glad to see this part of the bill, but I come now to the very disappointing aspects of this bill. As I've indicated, any attempt made by the MOJ to suggest that these reforms in this bill aim to make the criminal justice system fairer are undermined at the very outset by the provisions in Part 1, which will result in a cut of roughly £450 million a year to the legal aid budget. The consultation document boasts that legal aid will be retained in cases where people's life or liberty is at stake, or where they face the threat of serious harm or immediate loss of their home, or where their children are going to be taken into care. This set out almost as though we were meant to applaud this magnanimous decision, even though this self-same document proposes to slash legal aid for almost all private family law cases, cases of clinical negligence, employment, immigration and all but the most severe debt and housing issues and welfare benefits. It is telling that the government response... Yes, I give way.
Thank the honourable member for giving way. And would my honourable friend agree that what is particularly difficult about this is the timing of these proposals, which are coming at a time when the government's proposing major changes to the welfare system, which will leave many of those wishing to challenge unfair decisions without access to legal aid at times of most need?
Absolutely right, and the Honourable Lady has hit on a very important point. It's the wrong time for this bill in any event, and I would hope government will pause in committee to think again. As I set out in my contribution to the legal aid debate in February, if these reforms were implemented, they will in fact create a market for legal aid, driven by cost rather than by the needs of clients. The most vulnerable people, including those with mental health problems and other disabilities, will find it almost impossible to gain access to free legal advice, because their cases will be too complex for firms to take on. And the Ministry of Justice's own equality impact assessment in fact acknowledges that the losers will be predominantly women, 57%, ethnic minorities, 26%, or disabled or ill people, 20%. The proposals about which I am most concerned, that of removing ancillary relief and private family proceedings from the scope of legal aid, remain largely unchanged, despite respondents, including myself, arguing that not all cases could be successfully diverted to mediation, that without early legal advice, fewer cases would settle, increasing the burden both on courts and on those involved in disputes, and that the decisions in this area should be delayed until the outcome of the Family Justice Review. But these pleas have fallen on deaf ears. Ancillary matters such as child custody and maintenance will not be dealt with, I'm afraid, sensibly, and it is difficult to overestimate the devastating effect this will wreak on children caught up in these kind of disputes. And I speak with one who has 30 years' experience in family cases, both as a solicitor and barrister, and I should declare many of them publicly funded. In its response to the consultation, the government conceded that legal aid should be available for victims of domestic violence. This is an important step, since in 2005, a study by Tridner and others, 53% of women reported physical or emotional abuse as a cause of separation. Sir Nicholas Wall, President of the Family Division, has pointed out how ill-advised the government is to concentrate on domestic violence alone. Abuse, as Sir Nicholas Wall said, is much broader and can be psychological, often financial and emotional. One size fits all simply will not work with the complexities of our justice system. And the cuts to legal aid, I believe, will increase rates of injustice, which is very difficult to square with what the Prime Minister has said about these reforms. He said last week in a press conference on the wider reforms being proposed that his mission was to make sure that families should feel safe in their homes. A worthy cause, of course, but when you look at the detail of this bill, there are many, many problems. Vulnerable people will be left to go it alone. As Justice has said, the duty of a democratic society should be to ensure that members of society abide by and benefit from the provisions of the law. Both these considerations appear to be missing from these cuts. You don't need to take it from me to understand how dangerous these moves are. The European Court for Human Rights has criticised them, the UN Human Rights Committee and Council, amongst others. Our justice system should fit everybody, not the few. And the cuts in legal aid, these cuts are crude, they are cumbersome and they are callous. And the cuts to the scope of legal aid, not only will they undermine the reforms the government is promoting, if implemented, they will undermine the very principles upon which our justice system rests.